following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 24th of February, 2016 are currently trading with gold at $1,238.20 an ounce, silver $15.28 an ounce, Texas crude $31.87 a barrel, and Bitcoin is currently sitting at about 423 U.S. currency. Today in history, the year 303, the great persecution of Christians in the Roman Empire signed into edict by Emperor Diocletian, in effect stripping the legal rights of Christians and demanding that they comply with the traditional Roman religious practices of the day. In recent news, the State Stop Criminal Court dismissed criminal charges against Rick Perry for his 2003 threat to veto state funds to the Travis County prosecutors. The charge itself, it was ruled 6-2, violated the Texas Constitution's separation of power provision by limiting the governor's veto authority. Presiding Judge Sharon Keller stated that the governor's power to exercise a veto may not be circumscribed by the legislature, the courts, or the district attorneys. When the only act that is being prosecuted is the veto, then the prosecution itself violates the separation of powers. The court has also dropped a secondary felony charge of coercion of a public official as a violation of free speech rights. The International Monetary Fund stated today that the global economy is highly vulnerable to adverse shocks and is calling on the United States and other major governments to prepare contingency plans that could be used to stimulate and boost growth. IMF is strongly suggesting that the world's 20 largest economies should keep pursuing strategies for growth, though they did suggest that they should develop additional measures that could be implemented immediately if economic growth continues to slump. With the IMF suggesting governmental spending as a means of stimulus, it's hard to take the Treasury Secretary Jacob Lewis's statement serious when he stated that it's not the job of the finance ministers and central banks and governors to accelerate a crisis. It's their job to avoid one. Yeah, sure. MasterCard has announced plans to introduce Selfie Pay to more than a dozen countries, a program that is part of MasterCard's plan to implement biometrics as a form of security authentication. The idea is simple. Users will take selfies through their app, and the image will be stored into a company's server. Every time anyone will want to make an online purchase with their credit or debit card, they will be prompted to look into the phone's camera so that the image can be digitally matched and compared against the selfie on file, effectively changing the selfie for the traditional password. This was your lowdown for February 24th, 2016.
My remedy today came in a box just like they say. I accepted it for value right away, if not sooner, not later.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Chris in Pennsylvania. Okay, Chris, I have the Fannie Mae Freddie Mac uniform instrument for Pennsylvania, and apparently, Pennsylvania is not a deed of trust state, but is a mortgage state.
Correct.
Yeah, this is a mortgage. So I'm looking at the document, and in the uniform instrument, there's no reference to MERS. Now, I have seen documents that are designated Fannie Mae Freddie Mac uniform instrument with MERS, but I can't find any on the Fannie Mae Freddie Mac website. Do you know if your mortgage is labeled the 3039 uniform instrument form 3039 or uniform instrument 3039 with MERS?
I believe it's a 3039 with MERS.
Okay, I can't find that on Freddie Mac's site. So
yeah,
it's labeled in the footer as a Fannie Mae Freddie Mac uniform instrument.
Right.
But is it a uniform instrument? And that's important because if this is a uniform instrument, you have a right to a reasonable expectation that everything in it is ordinary and normal. I'm sorry, the term I was looking for is regular. So because it is the standard contract that most everybody uses, you would not reasonably need to read and scour every word and every sentence quite so carefully as you would if it were some document made up by the lender. So by using this header or this footer, they would mislead you into thinking this was a uniform instrument when it may well not be.
Right.
Am I making sense there?
Yeah. Oh, yeah.
So, in one of earlier on when we were earlier in the process of going after these issues, this was one of the issues we took up. That's in some of my pleadings, that not only that the document is not a uniform Fannie Mae Freddie Mac uniform instrument, but that the document is too vague to be enforceable.
Right.
And if there's vagueness in a document, the responsibility for the vagueness goes to the creator of the document.
Right. That was my contra preferentum ploy to you, which is basically, ambiguities are to be construed unfavorable to the drafter.
Yeah, okay, that was that's the verbiage I was looking for, and it was in there somewhere, but I lost referential index. As you get older, you lose referential index when you sleep. I think it seeps out your ears. But yes, any ambiguity in the contract is attributed to the creator. So you came to the table, and the lender brought this document and put it in front of you. So if it's not understandable, then that's the lender's problem, and we've made that argument a time or two.
Right. Yeah, that was the whole gist of that being fraud on its face. We've gone over things.
Have you attacked the document separate? What are you in court with now on the foreclosure?
We're in court now. We're just waiting for the motion to reconsider his summary judgment based on the fact that it wasn't placed with a brief, even though the bank's statements were addressed as for their summary judgment. There just was no brief. So
did they give you opportunity to file a brief?
No, they did not. Well, they gave us time. It just didn't get in. She didn't notice that the judge asked for a brief. He was looking for an answer to the response by the bank.
Oh, okay. So that's you're still you're just setting the record for appeal.
Correct.
So you have the issue with no answer from the bank. Did the bank initially respond with a motion to dismiss?
Yeah, they responded with.
Let me rephrase that question. Did the bank respond with a motion to dismiss within the time limit for filing an answer?
No, they did not. It was 6 months. It was in July we placed the answers to their summary judgment, and it was just 3 weeks ago we heard of his judgment. He just made judgment on that, with no responses from the bank in between that.
So you filed a motion for summary judgment, and the bank did not demur to it, didn't object to it?
No, the bank put in a motion for summary judgment based on the fact that there was no evidence warranting the continuance of this of the case. So the judge ruled in favor of the bank, not for reasons of no evidence, but for reasons of no submission of a brief to the answers why there was legitimate evidence to continue the case. Does that make sense?
I'm not sure. I need to back up and see where the case actually was. You had a unanswered petition that wasn't answered within the time limit, and the judge allowed the bank to continue even though they failed to meet a filing deadline.
No. We were in a discovery, and the bank did not file. They gave us the answer to our interrogatory.
No, wait, hold on. You said the bank didn't file an answer to the lawsuit. They filed a motion for summary judgment instead. And a motion for summary judgment can take the place of an answer. Because the courts will say, if there's cause for summary judgment, it would be an undue imposition on the defendant to have to prepare an answer. So you can file that motion for summary judgment, but it has to be filed within the time limit allowed to file an answer. So you're saying they didn't get their summary judgment in within the time limit, but the judge allowed it anyway.
I believe so. I wasn't aware of a time limit to file a summary judgment.
The first response must either be an answer or a summary judgment can stand in place of an answer. If you're ruled against on the summary judgment, then you have to get the answer in within the 20 days. When the summary judgment is filed, the clock stops. When the summary judgment is dismissed, the clock starts again. So if they file it on the 19th day, you got one more day to file an answer. So in this case, they didn't file an answer. They filed a motion for summary judgment, but the summary judgment was not within the time limit that they had to file it, so it was out of time. And the court allowed it.
Okay.
Now they're claiming that your lawyer failed to get a brief in within the time limit, and they didn't allow that. Great thing to go to the Court of Appeals with.
Well, we're still waiting on her motion to strike his judgment based on no brief, because it's in Pennsylvania, it's only sanctionable through fines. It's not what should produce a judgment on the case.
And that's reasonable, because it's unreasonable to rule when you have no evidence. Okay, so let me understand this. Did the judge dismissed instead of sanctioned?
He dismissed instead of sanctioned, correct.
Okay, and you're saying that he didn't have power to dismiss?
No, not for not entering a brief. We entered an answer to the summary judgment timely, which she believed there was no need for a brief. And in essence, he wanted a brief, didn't make that clear. And 6 months later, after entering this, he's now come to a judgment on the summary judgment in favor of the bank for no brief, not because we didn't show evidence.
Okay, so he didn't rule on the merits.
No.
It sounds. Sometimes I listen to these cases, and it sounds like the lawyers are just trying to keep the case going, and it sounds like the judge is helping. Why would it doesn't make sense that the court would do that. All it does is add to the foment litigation.
Right. We're wondering why he didn't make ruling on the essence that we have plenty of evidence to why this case should be going, because of the things that appear on the assignment, as well as my interaction with the homeowner's insurance, showing that the chain of title has been broken several times. We're not even sure if this bank, and then there's Fannie Mae being claimed as the lender by the bank. So there's all this ambiguity in here as to who the real lender is. The bank's making a statement they're merely collecting a debt for the lender, and the bank is saying that they have a mortgage and a note. But the bank took this.
Okay, has there been an actual foreclosure, or is this a motion to? Is this a defense to a foreclosure?
This is defense to a foreclosure. Okay, they haven't sold the property yet, and that's sale. So good. We'll come back and want to talk about quiet title. Hang on. This is Randy Kelton, Rule of Law Radio. Our call-in number 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get behind you. Know what I mean? My friend. And all of your children. Come. Those things that hurt me free. Tell him your problem, babe. Call on his name once again. Miracle, you know you worth the aim. Trust in God, my friend. Tell him your problem, babe. Call on his
Okay, we are back. Randy Kelton, Rule of Law Radio, and our call-in number is 512-646-1984. Our call boards are empty tonight. I guess I put everybody to sleep with that ebook presentation. But if anybody's waking up, you might want to call in. It tends to build up toward the end. And so we have plenty of room, so give us a call. We're talking to Chris in Pennsylvania.
Yeah, Randy, I'm serious. We keep searching my Kindle for your ebook.
Oh, I don't have it. I'm still working. I'm still building it. That's what this presentation was about. I'm trying to get some of these. These are issues that I haven't talked about before. So while I understand the issues, I haven't presented them. And in this case, I'm talking to a microphone. I can't see my listener. So if it sounds like I'm struggling in the presentation, then that's correct. I am struggling in the presentation. But you have read some of the neurolinguistic programming materials. Which of the books have you been through?
I've been through the Frog and the Prince you've given me. I've also downloaded a slew of books on my Kindle that talk about the therapeutic use of it, through pacing and leading and then setting focal points and going on to change how you think about something.
One of the issues that I was looking to go to on the Artful Vagueness section was the information you'll find in Structures of Magic. Have you read that one?
Yes. That's one in the book, in my Kindle that I have to read yet.
Okay, Structures of Magic. It's kind of dry as gunpowder. It was a book written by therapists for therapists, and they studied language as it's used in therapy. This is a tool I use on occasion on the show. They call this the meta model, and the portion of this I was going to talk about in the ebook. I probably won't go into the application of the meta model, although it is extremely powerful. The meta model is a procedure whereby you enter no content to a situation. There have been a few times when I've had people call into the show that frightened me because they were so distraught that I was afraid they were going to hang up and go out and shoot themselves or something or do something horrible. There's been about 3 or 4 times like that on the show where I got someone that was in serious need of help. And when I get that, I shift into the meta model. And the meta model pays attention to deep structures and surface structures. In the earlier presentment, I talked about unspecified objects, verbs, and I think pronouns, where you leave out information or a conversational, not a conversational partialate. For the most part, when you're being artfully vague, you're leaving things out. And the meta model goes to the deleted deep structures that you speak in surface structures. But those surface structures, in order to be able to understand them, a natural speaker of the language understands that there are deep structures that give meaning to the surface structures. Like when I said he says he really made me mad. Well, that's a distortion deletion. It's a distortion because I have taken a process, acting in a way that we describe as angry. The description of this process is a nominalization where we take a process and turn it into a noun. So I use the nominalization mad, and that goes to what we talked about earlier, is I'm losing the term, I hate it when this happens. And this gets worse as I get older. A complex equivalent, where when you create a nominalization, when you take a process of acting in a way that we would term as angry, and we call it angry, we have deleted the actual process from our speech and only given this label. And we expect a natural speaker of the language to go recover that deep structure and create meaning for the nominalization angry. Well, in the meta model, instead of offering anything to the individual, you use questions to try to elicit the deep structure. So when he says that he really made me angry, well, how did you act when you got angry? I'm taking their own terminology and ask them to be more specific, or ask them to fill in the deletions that they left, out of the surface structures.
Right.
That's very powerful when you're like, if the wife comes in and she's really angry, and it took me a long time to understand about women, we're guys, we want to fix everything. They're not asking you to fix everything. So if you can't do the normal thing and fix everything, what do? Well, you pull out the meta model. And when they use distortions or deletions, you ask them questions to elicit the information they left out. And what that does to an individual is it presses them to go in and gather up from them for themselves a more complete representation of what they're feeling or thinking. The deletions, distortions, and nominalizations of ordinary speech are not only deleted from the listener, they're also often deleted from the speaker. I was watching a program on the unreliability of witnesses and the unreliability of memory. And in some research, relatively recent research, they made some astonishing discoveries. We have people that are over 100 years old, and they have a very good memory. They can remember 100 years worth of experience. And we look at that and say, my goodness, that is an incredible amount of memory. Well, it may not be quite like we think it is. It appears that when we access a memory, that we essentially delete it and replace it with our current memory of the event. Say someone tells me a story. And it's a great story about something happening, and then I tell it to somebody else. When I tell the story to somebody else, if it's not important where I got the story, then I delete that from the story. And it turns out what the memory does is when I extract the memory, it erases it. And then when I experience the memory, it puts it back. So it only keeps, instead of me remembering, and then remembering all of the times that I told the story, it just remembers the last instance. And it tends to save what's relevant at the moment. So it tends to erase the information that was otherwise very relevant because we didn't include it in this incarnation of the memory. I hope that's making sense, but it helps to explain a lot of these anomalies that we see in human behavior. Hang on, we'll be right back.
I only have eyes for you. Soon, store mannequins may be singing that tune. They're being outfitted with cameras to watch us while we shop. I'm Dr. Catherine Albrecht, back with details after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
It's disturbing enough that big brother governments use facial recognition technology to identify and track people on the streets. Now clothing companies in Europe, Canada, and America are getting in on the act. So where do they hide the cameras? In the eyes of mannequins. That's right, those glamorous plastic ladies in the display windows may be watching you back. They're called eye seers, and their job is to log the age, gender, and race of passersby, so retailers can devise new schemes to get you to buy. But hang on, aren't mannequins spooky enough already? This is taking weird science to a whole new level. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Chris in Pennsylvania. And I know this sounds kind of way out there, but it really fits, and it makes a lot of pieces fit together. They did some experiments with rats where they exposed the rat to certain experiences, and they had developed a chemical that if they injected the rat with it, rat would be unable to store memories. So they could expose it to situations once they give it this chemical, and then come back and expose it to that situation again. It would have no memory. Like they could give it an electric shock and it would run away and be frightened, and then the next time it wouldn't be frightened at all because it would forget it. And then they exposed the rat without the chemical to an electric shock, where when he tried to get food, it shocked him and he'd run back and hide. And then they gave him this chemical and exposed him to the same thing. And the rat went up, got shocked, ran away. And then the next time they put the rat in the cage, it ran up, got shocked, ran away. Had no memory of being shocked before. So it had the memory, and then it activated the memory when they put this threat in front of it. And when they blocked its ability to store the memory, they found the memory had erased itself. It was not expected. That was not an outcome they anticipated. That when the rat extracted the memory, he actually took it out. And then when they blocked it, he couldn't put it back. And it's important to understand that. I mean, I get people coming on the show, and they're very distraught. We ask them, you've heard me ask people for timelines. I had to go to timelines because I can't ask for a statement of facts. If I ask for a statement of facts, what I do is I force people to go relive the bad experiences that they had. And they pull these bad experiences out, and they've done this 100 times. We go over these things. We have the experience initially, and we don't pay conscious attention to everything. We pay conscious attention to what seems to us to be important at the moment. And then we get in a separate situation where we have to remember what went on, but we do that from a disassociated perspective. So we're not in the experience, we're remembering the experience. So there's a different set of criteria. So we pull that memory and examine the memory from this different perspective, and then put the memory back without a lot of these connections that were not important for this particular memory access. Like when somebody tells you a story, then you tell it to somebody else. If the person that told you the story wasn't important at this telling, then you won't access that information. So when you put this memory back, you don't have referential index to that information. Now, apparently with further experimentation, that information can be retrieved, but it takes a roundabout way to do it. And that's what the meta model is about. You start asking them to go in and fill in those blanks that they've left empty with these re-experiencing of the emotional content. You've probably heard me talk about how sometimes we lose sight of the prize and it becomes about the fight. And that's because people have these bad experiences and they relive these experiences, and each time they relive it, they rehave the emotional experience, and it tends to get worse each time. And by the time they've told it or rehashed it 50 times in their mind, it's become so traumatic they can hardly even think about it. And it becomes far more traumatic than it was when it originally happened. Mm-hmm. So the meta model is a good way to help other people go in and reattach these referential indexes, re-access information that they've lost the way to access. It's not so much that the memory is lost, is we've lost our ability to directly access it. And the meta model is very good for that because it keeps the individual out of the content. You pay attention to the predicates people use, to the descriptive words, and ask them to give you more information on a more detailed description. He threw a ball at my head. Well, what kind of ball was it? What color was it? Did it have a dent in it? You ask a stupid question like that, and they'll have to go re-access that ball and pick it up in their mind and turn it around and examine it to see if it had a dent in it. And when they do that, they'll reconnect to the original situation in a way that they otherwise wouldn't. So you might look up the Structures of Magic. They're 2 volumes, and they're pretty dry and technical, but they are absolutely incredible. Those 2 books are the original foundation for neurolinguistic programming.
Right. I think I started them, and I think that they were so dry that I tried to look at other books referencing NLP techniques. Well, ease myself into something more.
Well, now, Frogs to Princes was a lot more interesting book to read. One of these in the series, there's Frogs to Princes. These are taken from seminars that Grinder and Bandelier did back in the 70s. Frogs to Princes was the first one. Reframing was the second one. Transformations was the third one. Transformations I've probably read half a dozen times. It has so much incredible information. If we could get 2 or 3 people in every county who understands some of these techniques, we could have an incredibly dramatic effect on our legal system. Mm-hmm. When I go into these courtrooms, they have a very hard time dealing with me. And the primary reason they have such a hard time dealing with me is that I'm dealing on a level that, for the most part, is outside their conscious awareness. They have no conscious clue. And neurolinguistic programming helps you to understand the nature of how that works. Because a lot of what we're doing every day, we're aware of, just not in the conscious part of our mind. And we don't know directly how to access that other part. I'll give you a real good example of how that works. You're driving down the road. You've got the radio playing, you're listening to music, somebody's in the car with you, you're having a conversation with them, and you're thinking about what you're going to do when you get to work. You got all this stuff going on all at once. And something moves in your peripheral vision. Bam! Everything stops. And you pay attention to the world around you, dead center through the center of your iris. Well, when something moves in your peripheral vision, you have another aspect of awareness. It is not subconscious. Subconscious is a horrible term. It indicates that things are going on that are outside your knowledge or control. Nonsense. This is in your control. It's just the way we've defined our environment or our experience that's caused us not to have direct access to it. Oh, I hear that annoying music. Okay, we'll pick this up on the other side. And this is about how we have a peripheral awareness that's far richer than conscious awareness. So I'll talk about that on the other side. Randy Kelton, Real Law Radio. We'll be right back. Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking about peripheral awareness. You pay attention to the world around you, dead center through the center of the iris. But you can see 170 degrees. So we don't have this capacity for nothing. And it's not subconscious. Our peripheral awareness is within our ability to pay attention to. It's not that it's subconscious or out of awareness. We're just not focusing on it. But it's working all the time. It's paying attention. You're driving down the road and a car approaches on a side road. Very quickly, your peripheral awareness will do some projections. If it looks at that it sees that vehicle in your peripheral vision and it appears to be fixed in position, then your peripheral vision will grab your focus and drag it over to that vehicle, because if it's in a fixed position, that means when you two reach this intersection, it's going to hit you. So it'll grab your vision and turn you toward it. So now it'll take the conscious focus and put it on what it considers to be a threat. Everything else that's going on in your environment, as complex as it may be, your peripheral vision, your peripheral awareness is paying attention to, and it's assessing it for level of threat all the time. The inner mind, the mind is the same way. You know, all of our senses detect a whole lot more than we pay attention to. Actually, they detect more than even the peripheral aspect of our awareness pays attention to. As much as that is, the inner mind does essentially the same thing. There's an aspect that I call our internal librarian. It pays attention to all of this stuff. It doesn't focus so much on the conscious aspect, what's going on right now. It only pays attention to it for the purpose of determining how we should react, the scope of our reactions. Angry, happy, sad, frustrated. All of these nominalizations we have to describe different ways of being in the world, well, that comes out of this other aspect. Something occurs, a situation changes, and it looks around and says, okay, in this kind of circumstance, we normally respond or react from this context. If it's angry, if some things occurred in the environment, and this aspect interprets this behavioral set as, or this set of circumstances is one that dictates this particular behavioral set that we call angry, it'll go open your angry drawer. And the conscious aspect is able to draw its responses from a narrowed set of behaviors. We're not left to experiment every time we have a new circumstance, a new situation. We've got all this experience. And the inner mind keeps looking for referential index, looking for clues that point at this context. And it opens this mental drawer. And in that mental drawer, you've got all the things you've learned to do in this kind of circumstance. If your parents were understanding and nurturing when they were angry, you may have that in there. But if they weren't, and you don't have that in your angry drawer, and you're not consciously aware of the limitations of the context that's just been accessed, you don't know what you're doing. You're just dancing around, doing whatever comes to mind, and you're not really in direct conscious control of your behavior. There's a way to fix that. Well, how to fix it goes to the rubber ball theory. But when I go into court, I am well aware of that phenomena. And if you're a public official and you want to dance with me, I'll give you a good one. Because I'm looking for ways to interrupt your normal patterns. Everybody is pretty well able to predict their environment. Especially when you go into a courthouse, they're very accustomed to people coming into the courthouse with a very limited behavioral set. And that's because we don't have anything to do with governmental officials for the most part. We do what we do out here in the world, and we have very little to do with these people. The only time we had a lot of experience with governmental officials was in school. And we learned how to react and respond to them in school. Then we get out of school, we don't have any more interaction with them. Well, we walk into a government building, and the inner mind looks around and says, okay, where do I find a behavioral set for government buildings? And it goes out and pulls out your grade school drawer. I watched a man who was in his 60s at the time. I was much younger. Really nice suit. We were out in the hall waiting for a traffic court to start. I didn't have a ticket. I'd come with a friend, so I didn't have a dog in the hunt. So I could pay attention to everybody else. And they're all huffing and puffing. Now they're going to get the officer fired, and they're going to read them the riot act and blah, blah, blah. We get in the courtroom. They call this guy first. He was obviously a high-level executive just from his posture and carriage. He walked up to the bench, or to the table there, and had some papers in his hand, and his hands were visibly shaking. And I was thinking, this is a traffic ticket. I mean, big deal. I mean, a couple $100. At the time, it was like $50 or $60. And this guy's obviously not hard up for money, so that's not a problem. What is going on here? It took a while to figure out what was going on. The only behavioral set he had for public officials was school. Now he's being sent before the principal, and he had opened his, I'm a 10-year-old being sent before the principal behavioral set. We need to fix that. And all you need to do to fix that is to be aware that a different behavioral set has been accessed. The first book in this NLP series is Frogs to Princes. The second one is a reframing. And a lot of what I do on this show is reframing. I take a situation that has a common referential index for people, like going into court, and I reframe that. What I want to happen is when someone goes into court, they don't access their being sent to the principal behavioral set. We want them to access their parent going to the principal wanting to know what in the heck you're doing to my kids. I want that behavioral set. That one works a lot better. And that's why I say when I walk into a public building, I'm the baddest motor scooter in the building. And this is a therapeutic metaphor. A content and context reframe. There's only one reason I'm the baddest motor scooter in the building. That's because I'm nobody. I'm not a judge, a prosecutor, a bailiff, a clerk. They're all public servants. I am the master, and they are not, to forget it. If we can do that reframe will open a whole different drawer with a whole different set of responses in it. And now you've got these officials who are very accustomed to people opening their I'm being sent before the principal drawer. And they get something else. I was just at the Department of Public Safety here in Texas because we have a new law that says if you get a Texas ID, you have to turn in your driver's license. So I went in there and told them I wanted an ID. Well, do you have a driver's license? Sure do. Well, you'll have to turn that in. I said, well, I don't want to turn it in. Well, you'll have to get an ID. I said, but I want an ID. Well, then you have to turn that in. I said, well, do whatever you have to. And she said, well, will you just wait over here? And she got a DPS officer to come out and talk to me. And I told him I want an ID. And they said, well, you'll have to turn in your license. I said, oh, that's what you make me do? Okay. Well, that's what you have to do to get an ID. I said, okay. And he said, now, if you do that, you can't drive out of here. I sure can. I just go in there and get in my car and I can wheel it right out of there. It's, no. I said, I'll pull you over and give you a ticket. And I smiled at him real big. I said, yeah, Bubba, when you pull me over and give me a ticket, I will give you a romp through the legal system you are not going to believe. And the look on his face was priceless. He certainly didn't see that coming. And that's what we want. Pattern interruption. What I did to him was not cause him to open a different drawer, but I stuck him. He was stuck not knowing what to do. And in human experience, there is nothing more emotionally powerful than not having a clue as to what to do. Hang on. Pick this up on the other side. Randy Kelton, Rule of Law Radio. A call-in number 512-646-1984. Chris, is this making any sense? Oh, Chris can't talk because I didn't even unmute him. Hang on, Chris. I'll actually unmute you when we come back on the other side. This is a top of the hour break, so it's a good time to go look at our sponsors. We'll be right back.
Story for everyone to hear about how we're not gonna give in to the fear. Yeah, it's a story.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're talking with Chris in Pennsylvania about neurolinguistic programming. Chris, Does that make sense?
Yeah, it all makes sense. I've been just what you talked about with the awareness factor. I read a good book by Bill Harris, who wrote a book called The Science of the New Age Science of Awareness, Super Awareness, and it touches on a lot of those things. I've been reading some Colin Smith and Lou Lawson.
Can you send me some links to that? See, I started studying neurolinguistic programming about 30 years ago, and when it first started, I picked up Structures of Magic in, I think, 1977 or 78 in a bookstore when it was still fresh, and been studying it ever since. But after about 8 or 10 years, neurolinguistic programming moved into sort of a gimmick stage where they had everybody had their own special little thing you could do, and everybody's trying to market their own little magic. And they got away from a basic understanding of the overall technology. I was frustrated with them. So I'm looking for people who have increased the technology. I think it's in Frogs to Princess where Grendelier states that if something seems difficult, that's merely an indication that our technology is not sophisticated enough. Mm-hmm. But I'm looking for people who have increased the technology. I am concerned that we are fast approaching a situation to where we, by our technology, will render ourselves irrelevant. If we don't do something, we have machines doing almost everything for us. And I have no concern about machines taking over. I do have concerns about human beings creating machines to kill human beings, because about the first application of automated aircraft is we used them to kill people. So in spite of Isaac Asimov's warnings about allowing machines to do no harm to humans, that's the first thing we want to do with them. But as to machines taking over, I don't see that as a problem, but I do see us reaching a point where we become irrelevant if we don't increase our own personal technologies. So have you found application to the NLP that you've learned so far?
Sure. I've found a lot of application, especially reading Colin Smith stuff. He's a guy you might want to read. He takes it into uses that benefit everyone, as opposed to some of these other guys who write books on the mastery of verbiage and in controlling others. His books are mainly how NLP can help you understand things as you put them with finding your not so much subconscious, but your awareness around things, and make you more conscious of that.
That sounds exactly like what I want to get, who I want to read. These tools these guys got where you think you can control other people. That's nonsense. Have you heard me present the rubber ball theory on the air?
Mm-hmm.
Have you heard me present the rubber ball theory?
Yes. Oh, yeah.
Okay. Well, the rubber ball theory, it examines this ability to pay attention to another level of awareness. But the one thing that once you learn to use it becomes absolutely clear: you cannot control other people.
Right.
You can put opportunity in front of other people to do different things. But if you try to influence them to do any one thing or the other in particular, and they catch you at it, it will have no positive effect.
Correct.
So forget this crapola. I joke about doing secret hypnosis, and I do conversational induction. But when you do these kinds of things, you can't manipulate people into doing things. What you can do is help people focus on and pay attention to things that have otherwise not been available to them. The only real thing you can do is help expand their technology. You try to manipulate people with this, they will catch you every time. And when I annoy these public officials, all I'm doing is making their expectation come false. Now, they can do anything they want to once I've tripped them. But when they try to manipulate a response from me, because they kind of know how you're going to respond, these are people who come to them at a terrible disadvantage. And they access an old, archaic behavioral set, and these public officials take unfair advantage of it. And when you trip one of them up, they find it a very profound experience. And it doesn't take much. This particular officer, he indicated that he was aware of this right to travel issue. Oh, you are? Wonderful. That's even better. Now you can't claim good faith reliance on competent authority and say that the prosecuting attorney told you this was okay. But anyway, this is not something, in spite of what a lot of people out there would indicate, is not something you can manipulate people with. Well, you can manipulate people, but you can only manipulate them to expand their capacity. And you can only manipulate them by making their expectations come false and forcing them to go inside and find new reservoirs of behavior. So from that perspective, it's absolutely ethical.
Yeah. And what you mentioned about timelines was something he touches on as well, as far as, for instance, they take professional bikers who look at coming to that wall and finding the energy to get through that by using timelines where they use triggers by either touching their tongue on their nose or on the roof of their mouth to focus on a timeline when they were exceeding 110% to draw them into awareness of focus at this point, to make themselves better in a time of need.
And one of the that's psychological, that's anchoring. And it is very powerful. And what I do here, a lot of what I do on the show is I try to establish new anchors, new ways, different ways of thinking about what's going on, so it leads you to a different set of behaviors than the ones you were accustomed to. You're on a bicycle and you feel good when you start, and you begin to feel fatigued, and you already know what the routine is. So you have this expectation of how this is going to go. Your muscles are going to start to ache. Your shoulders start to droop. Your mouth to hang open. You can barely get air. And then you trigger that anchor and take yourself back to a time when you weren't so exhausted and reset the whole clock. Yeah. A lot of athletes use neuro-linguistic programming to great advantage. For me, the real power of neuro-linguistic programming was it taught me how to reprogram myself. Right. When I present the rubber ball theory, I used to do seminars on it, and I would tell people that I'm going to present a tool here that you can use to elicit positive change in other people. And then at the end of the presentation, I would remind them that I said that. And I would say, when I told you that, I lied. This is not a tool for eliciting positive change in other people. Oh, yeah, it works for that, but that's a secondary purpose. That's just a side effect. This is a tool that will allow you to consciously and directly reprogram your own inner mind. You can rewrite yourself. And that's the real power of neuro-linguistic programming. Mm-hmm. Well, thank you very, very much, Chris. This is one of my favorite subjects and one that I haven't often talked about on the air. But I have Mark in Texas, and I know he's got something interesting. And I hope I answered all your questions and didn't just lead you down the rabbit hole.
No, we were doing fine.
Okay, so thank you very much, Chris. Now we're going to go to Mark in Texas. Hello, Mark.
Hey, good evening. You put me under a little bit of pressure. I don't know how interesting it is, but I just wanted to reach out. I've been listening to the show tonight. The discussion earlier is actually very interesting. With respect to, I want to formulate some good questions here. I'm looking at filing an FDCPA suit against I guess we call them a servicer, but what they really are is a debt buyer that bought something in 2013 or before, and a week later they filed, or actually within a few months, they filed an assignment of mortgage. And this assignment of mortgage is very interesting in that what it essentially has is it's saying that the assignor in this case is Mortgage Electronic Registration Systems as nominee of Fremont Investment. And this is in 2013. Fremont's out of business. MERS has no capacity to be an assignor in this state. And then the assignee goes and subsequently files suit. I attacked that in my initial response, but I didn't go into any great detail because I didn't really know how to do it at the time. And as I look at this, it becomes very interesting to me to think that the plaintiff in the suit is a party other than the servicer. This servicer sent me many letters as though they had some capacity to service this debt. They were trying to collect this debt. I'm within a 1-year statute of limitations at this point, and I hear your bumper music, so I'll hang if you want. But
yeah, hang on. We'll be right back. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Oh, come on.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Mark in Texas. And the debt collector, there was a question I wanted to ask earlier. When this servicer became the servicer, was the instrument in default?
Yes, they are absolutely a debt. They bought something which is essentially already in default, so they are a debt collector according to FDCPA, I believe, by that definition.
Absolutely.
Yeah. What I'm interested in asking, just for clarity, I'm looking for an attorney that knows something about this because I would prefer to have an attorney represent me in the action rather than go and suffer any kind of prejudice being pro se.
Send me an email. I've got one.
Question that I got to ask is this, because here's a difficulty, and if you think we can mitigate this is a good question for all the listeners to hear. I've talked to multiple attorneys in different states. The servicers in Utah, I talked to a guy there. He said, you don't have the chance of getting the kind of justice you want in this area that you would in, say, Arkansas or Texas. I talked to a guy in Texarkana, Texas. He said Arkansas is probably better than Texas, which is kind of surprising because so far I don't think so. But anyway, we're talking about the federal court. And everyone that I've spoken to in Austin, and there seems to be a very easy ability to find attorneys that do this in this area, they pretty much say that since this has some kind of indirect connection to a case that's already been filed and decided, that it's best that I file it in Arkansas. To me, I don't completely get it. I mean, they seem mutually exclusive. The assigner sent me something which is a violation of the FDCPA. This assignment was filed in 2013. It's invalid. It's fraud on its face. It's prepared by the assigner. The guy signs as a VP of MERS per this. Now this may be the thing that colors it. I need the state law in the state of Arkansas, which says MERS can't assign, in order for that argument to be truly valid.
Okay. Here's the deal. I've looked at several cases lately. I have a friend in Austin who's working with an attorney that does foreclosures only. I have another attorney in Austin who is the lawyer who got the Miller v. Homecoming decision. Homecomings, the one that says you have standing to challenge the assignment.
Okay, good.
And the cases that I'm reading, the Unova case, the one that just came out last week, it addressed the right to challenge the assignment. And it settled a split between the circuits in California. And it settled it on the side that you can challenge the assignment. All of the case
in my hearing.
Okay, all of the case law is very consistent in this regard. And thanks to Jeff Sedgwick, there is in the Unova case, Jeff Sedgwick and his group, this woman was a member of their group. And they used Jeff and his group's arguments. And if you've heard Jeff on the air, he keeps talking about the difference between void and voidable.
Yes, I see it.
That's it.
It's
that's what all these cases are saying. You don't have standing to challenge a voidable contract. You only have standing to challenge a contract that is void on its face. And what that means is you and I enter into a contract, and I sign the contract, and you don't sign the contract. Well, it's voidable. But I want the contract to work, so yeah, that's an issue, but I'm not going to raise it. So it's voidable if I choose to raise the issue, but if I don't, it's not. You can't, as an outside person, you can't challenge that contract. But if the contract is filed in the public record, or even if it's not, and if they try to use this contract in a court case, you can come to the court and say, this contract is void on its face. For instance, if the contract amounted to a conspiracy to commit fraud, you can say this contract is void on its face.
Okay.
And since it's void, it can be of no power and effect. And one of the cases I looked at was they had argued that this guy Bly had signed this assignment, had affirmed this assignment. He's a known robo-signer, and they claimed that the assignment was void because this guy signed it. What they didn't do is claim that the document was void according to Texas statute. And I forget the number of the statute, but we have a specific statute that says if a void contract is of no force and effect. They did not cite that statute claiming that the document was void as a matter of law. Therefore, the courts couldn't rule that it was void as a matter of law. So if we're going to attack this, we need to look for issues that would render the contract void. And in this case, what rendered it void was that Bly did not actually affirm this contract before a notary, because there's reason to believe he didn't sign it at all. So the accusation is he never even signed it, somebody else did. And there is a notary on it that the acknowledgement has to be void because he's already testified in court that people are signing his names on documents that he's never seen. So it goes to collateral estoppel. They can't claim this is not a problem. And you claim that because his signature is on it, and you need some evidence. The whole thing went to evidence. But you have to claim that it is void and not a contract that one of the two parties involved can challenge and render void. Does that make sense?
Oh, you bet it does. I've got that. I didn't voice the argument in that way, and it's not part of the record. But I brought out that it was fraud on its face. I think perhaps those are somewhat synonymous, but I don't know.
Let me suggest: have you filed a quiet title action against that document?
No. At this point, I've simply had one hearing after I first won the case, and then a year later, after the chain of events with aggravated perjury, the judge denying my right to due process by not hearing my challenge to subject matter jurisdiction, and denying my right to due process by violating a state statute where it literally says that in order to reopen a case that's already been decided, under any circumstances, the plaintiff has to have a valid prima facie cause of action. I put that in my motion. I just putting it right in front of them. Didn't do a thing. But I'm wondering strategically if it would make sense for me to file an FDCPA action against the servicer, because these letters they've sent are in violation. It's not a valid debt. They're attempting to collect a debt for a party that is actually not involved in the dispute. You know, I've read some case law where they actually just break it down like that. I think one of the decisions from Judge Shack or whatever in New York, he's saying.
Yeah, I'm familiar with him.
Yeah.
He's the one that calls them vampire lenders, where there's an assignment after the lender went out of business.
Right.
And they rise up from the dead and give order to foreclose, or to transfer. Hang on, Randy Kelton, Blue Law Radio. Our call-in number 512-646-1984. We'll be right back on the other side. Go check out our sponsor page and buy all the products on there. Help to support this thing. We'll be right back.
Candy, soda, and cupcakes may please your taste buds, but did you know that binging on sugar can slow down your brain? I'm Dr. Catherine Albrecht, and I'll share new research showing how sweets may dumb you down next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Attention sugar junkies, if snarfling sweets and guzzling soda is your thing, I've got some not-so-sweet news for you. A new study shows a diet high in fructose could make you dumber in just a few short weeks. UCLA researchers gave lab rats fructose in their drinking water while training them how to navigate a maze. After 6 weeks of sucking sugar, the dazed animals began to struggle. In fact, their overall brain function diminished noticeably. Still want that fudge sundae? Then eat plenty of foods rich in omega-3 fatty acids. Rats who ate omega-3s zipped through that maze much faster than those that didn't. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
We'll be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see two. You ever done I see tools of ingenuity to use against the workers of iniquity. Tools of massive capability, available for all eternity. Yeah. They come from natural divinity, with steadfast roots and authenticity. I see tools to regain dignity, to rebuild the credibility. And I say, truth in nature must be justice, I believe. Truth in nature must be justice. And though it's a daunting task, at least I got the decency to ask them all to just take off the silly mask. And in the light of day we all will pass, and we'll be tools of ingenuity, use against the workers of iniquity. Tools of ingenuity, use against the workers of iniquity. As tools of ingenuity, use against the workers of iniquity. Tools of massive capability, available for all eternity. They come from natural divinity with steadfast roots and authenticity.
Okay, we are back. Randy Kelton, Blue Law Radio. And we're talking to Mark in Texas. I'll get you unmuted here in a second. There we go. Okay, Mark.
Hey. Okay.
So, FDCPA, how long has it been since this new servicer became servicer?
They became the service in 2013. They filed the assignment
Wait a minute. I'm having a terrible time hearing you. Are you on a Bluetooth? Wait a minute. You're breaking up so bad I can't understand what you're saying. Yeah, I think I'm losing you altogether. Can you hang up and call right back in?
Yeah, I'll call back in.
Oh, there you go. Wait a minute. There you go. Hold on. You're good now.
Got me? Okay, perfect.
Gotcha.
Well, the short of it all is that as far as the assignment itself is concerned, it's something which is void. I would like to attack it through discovery that I could do in an FDCPA suit. The quiet title action makes sense. And then what I hope to lead up to in this case would be a fraud suit. And if you know someone who might possibly represent me in federal court here in Texas with that kind of matter, and they could handle it even though it's in Arkansas, I'm okay with that. I'd definitely, be interested in that.
let me make a suggestion on strategy.
Sure, please.
Probably the least complex for the judge, and most likely the easiest decision to get, is a quiet title action.
Okay.
Because quiet title action doesn't go to the debts. It goes to a document filed in the public record. You're not asking the judge to render a ruling that can change the world as he knows it.
Right.
You say to the judge, you have this document filed in the record here, and there are anomalies with the filing of the document. This document does not meet the statutory filing requirements. The only thing we're asking is that you rule that this particular document, based on this particular set of facts, is insufficient for filing and is therefore void and of no force and effect. So he only has to measure the filing of the document against the statutory filing requirements and nothing else. You ask for no damages of any kind and do not allow him to attach any damages. If he wants to sanction somebody, let him sanction them. But you strictly declaratory judgment, no money involved. You just want a ruling on the validity of this document. If you get a ruling that the document is void, 30 days after you get that ruling, it cannot be challenged again. It becomes res judicata, and anyone attempting to rely on that document is subject to collateral estoppel. It's kind of a pawn move.
Okay. Is it also
now,
that they can't?
Once you got that ruling, now when you go for FDCPA, it's already a done deal.
Oh, I see what you're saying.
So you sneak up behind them.
I'm not sure I have time, which is another bummer. I think the last letter I got is in March. So here I am close to the end of that. Here's a question.
Now, wait a minute. March time for what?
I have a 1-year statute of limitations on FDCPA, and the last letter I got from them, as far as I know, was in March. Could have been April or May. I've got it all together, but I haven't even gone back and created the timeline that I.
Then in that case, you might want to run them together.
Yeah. Okay. File them at the same time.
Right.
If that's what you mean, because my FDCPA action is going to take longer anyway. If I file discovery and then have to compel them to do it. I figure in federal court that's going to happen. I hope, but I see what you're saying. Actually, the two tie together, and then if I have a judgment, we wait 30 days, and then we throw that into the documents are submitted to the federal court relative to the FDCPA suit.
Right. Where was the assignment verified? Where's the notary at?
Okay. The notary is in Utah. The notary and I can read it. I'm looking right at it.
No, that's enough. I was looking for a actor who is in the state of Arkansas. You get one defendant in the state of Arkansas, they can't remove it to the Fed.
Okay. I see what you're saying. I don't know if that can be done at all. It was prepared by. It literally says prepared by, and it gives the name of the party signing it, and this party is clearly noted as an employee of the, or at least it seems that it's knowing that this person is an employee of the servicer. So the servicer is preparing this. It's got an investor number, it's got a MERS number, it's got a VRU number. Later on in some documents subsequently submitted to the court, these were redacted as though those were precious things to protect. But it was prepared on July 30th. The assigner is Mortgage Electronic Registration Systems as nominee for Fremont, its successors in the signs. Fremont's out of business in 2008. Couldn't have made this. MERS can't make this. and then I've got an assignee, U.S. Bank as trustee, J.P. Morgan, blah, blah, blah. And it goes on. And it talks about what it really says on the page.
You cannot keep this out of federal court. So I was looking for a way to get it in the state, so there's no way to get, the actors will have to be notified. So this will have to go to federal court because of the diversity jurisdiction.
Okay.
But it's a separate issue from the FDCPA, and what they will try to do is join the issues, and you absolutely want to object to that.
Okay. You mean the FDCPA and the quiet title actions? Keep them separate.
Right. The quiet title is simply declaratory judgment. And if you allow them to join them, they're going to try to tie the declaratory judgment into the claim against the debt collector, and then that'll destroy the declaratory judgment filing.
Got it. Here's a question. This is something I've wondered. You'll know the answer. On this thing, at the very top of the document, it says recording requested by Richmond Monroe Group. When recorded, return to Richmond Monroe Group in Missouri. Who the hell are these guys?
That's probably just a law firm that's handling the paperwork. Hang on, Randy Kelton, Real Law Radio. We'll be right back. Okay, we are back. Randy Kelton, Real Law Radio, and we're talking to Mark in Texas. And yeah, I would want to keep these apart if there's any way I can. I would actually. How long have you got on the FDCPA?
I have probably 1 to 3 months, somewhere in there.
Then file the trespass to try title. No, I'm sorry. I keep saying that. A quiet title action first and get it working. I was thinking on the way out, who filed the document? Was it actually this group out of Missouri?
It's just saying recording requested by, and when recorded, returned to. It says it is prepared by. It's prepared by Bill Cook Select Portfolio Servicing, Inc. And then as we go through, we see MERS nominee for Fremont. We come down and on the second page, it basically says MERS Electronic Registration Systems, Inc. on this date by, and then it has Bill Cook signing as Assistant Secretary. So I would figure discovery would be something where we're asking, okay, is Bill Cook an employee of this organization? How can he prepare this and sign this document on behalf of MERS as though MERS is making this assignment?
Wrong question. Wrong question. They can answer. He's under contract with MERS. He's not really an employee of MERS, but he's under contract with MERS.
Okay, got it.
The real question is, this document's a forgery. In the Inova case that just came out, and it quotes a number of other cases, and they all pretty much say the same thing, that only the bona fide holder of the note can order the trustee to foreclose.
Okay.
So who ordered? We can extrapolate that to say only the bona fide holder of a security instrument can order MERS to transfer that security instrument to another party.
Right. They're out of business in this instance. And according to the Supreme Court case in Arkansas, MERS doesn't hold the note. They don't take the payments. They can't do this at all. That's given very clear, plain language.
Then file criminal charges first against whoever it was that affirmed this document.
Oh, yeah?
File them in Pennsylvania. File them in Arkansas.
Really?
Sure, that's tampering with a government document. Aggravated perjury.
Okay. This person is saying that he has capacity. Is that the perjury? He's saying that he has capacity to take this action when he doesn't have this capacity.
When he can't as a matter of law, because he's claiming to be an agent for a dead guy.
Got it.
How did the dead guy order you to give away his property? This is what Judge Schreck went to in New York, calling them vampire lenders. They rise up from the dead and give orders to their agents.
Wow. Well, that becomes very interesting.
And nobody takes them on that way. This This aggravated perjury, tampering with government document, tampering is generally a felony. Aggravated perjury is certainly a felony.
Yeah. Are there civil penalties for this kind of thing?
Absolutely. And criminal doesn't have anything to do with civil. Criminal doesn't in any way affect your civil remedy. But what criminal will do is affect the politics. This guy's probably filed 1,000 of these.
Oh, yeah, that's a good thing.
He's going to be jumping up and down. Now they have something more important to worry about than your mortgage.
Would it be a good course of action to contact the Attorney General and try to get them to hammer this out?
You might look at the Criminal Procedure Code in Arkansas.
Okay.
Wait a minute. What we might be able to do is file it in the Fed. But the problem with filing in the Fed is they're more political than anything. The FBI is just simply bought and paid for.
Yeah, I know that.
Yeah, and it's hard to get them to do. You're more likely to get something done in the state. The act was committed in the state, and just because this guy, you don't know where this guy lives, apparently.
Don't know where he lives?
Yeah, the guy who signed the document, does it have his personal address on it?
No, it doesn't have his personal address. It seems to suggest, and I've seen it in affidavits and other cases by Lynn Zavoniak and others. These are calling him robo-signer in a lot of instances, but it seems to simply suggest that he is indeed an employee of.
No, I'm getting at venue or at jurisdiction, where I'm looking at a way. Oh, what is the? I'm looking at a way to file in the state. And keep this in the state.
I got it. They're in Utah. They filed it in a county in the state of Arkansas. It would seem that this action is being taken within that state, and it's a matter within that state to me. But beyond,
was the notary in Utah?
Yes, the notary is in Utah.
Okay, then the notary would be named as well. Well, not necessarily. The notary only verified the signature, but that indicates that it was signed and that the act was committed in Utah.
Right.
So you might file criminal charges against him in Utah. Now, there's no way, I can't see a way to keep it in the state. This will go to the Fed. So it probably should be filed in the Fed, and you can file it in the Fed local to where you're at.
Well, we've already discussed that, and that's great.
Well, it's an interesting fight to have because we've got a way of going after the U.S. prosecutor and bringing political mayhem on him that he's not going to want.
Yeah, I'm figuring if and here's a question for you. If it's filed in the Fed, then the Fed is a lot more friendly to MERS than the state law would be in the state of Arkansas. And that this is something that's only criminal and aggravated perjury and wrong and invalid and void on its face based on the law in the state of Arkansas, from what I understand.
So Arkansas may be the best place to file it. I have someone else on the line. Let me bring him up.
Okay.
Hello, Mark.
Hello.
Mark, I want you to meet Mark. Mark, meet Mark.
Hello. Hello. Hey, Mark.
This is the other Mark I told you about in Wisconsin, and I'd wanted to introduce you to for a long time.
Yeah. Hi there. Hello. Thank you.
You two are both causing lots of trouble, and Mark, you might be able to help. Mark, this is confusing. With the FDCPA, haven't you done a lot of debt collection stuff?
I've done very little debt collection stuff. I've spent most of my time going after and making trouble for lawyers directly. The debt collection stuff, I'm familiar with it, but...
Okay, that must be... Well, I've got two Marks from Wisconsin. Are you in Madison?
No, I'm not the Madison one.
Okay, we have a Mark in Madison, Wisconsin, and he's the one that worked over the debt collector, so these are the wrong ones. Okay, back to Mark in Texas. Yeah, I think nobody's been doing this. Nobody's been taking this tact of going after these guys criminally. And Mark in Wisconsin is going to like this part because he's a troublemaker. You know how those Yankees are. They like to start trouble.
Oh, if I knew how to do it, I'd be doing it too. So I'm open to learning.
Well, the way I'm looking at this as, I keep saying everything's political. In the end, it's not about the law. It's about politics, and politics is all about the money.
All right. How do we get the states and the attorney generals involved? They need to recognize criminal activity happening inside their states so that they can get off their asses and do something. I hope I can say that.
You can file a complaint with the attorney general in the state, because he has, in most states, the attorney general has prosecutorial powers. Not here in Texas, but in most other states they do. Mm-hmm. But if you you listen to what we do with running the process on people, on public officials, the routine is you can do the same thing with the Fed. You file a complaint with the federal grand jury, and the prosecuting attorney will pick it up and secret it from them. And then you file against the prosecuting attorney, and you start creating ugly politics for the federal attorney, the U.S. attorney, and he is not going to like that. And get him to go back and pressure these guys. I am sorry, we are out of time. Mark, Wisconsin, I'm sorry we didn't have time to get to you. If you'll call in next week, you got to call in before the last segment.
Put us together via email if you can, please. Please, yes.
Send me an email, Mark, and I'll in Wisconsin. I'll send it to Mark in Texas. I'd like to get you guys talking.
Will do. Thanks, sir.
All right.
Thank you, guys. We'll be back next week. Thank you all for listening, and good night.
Size, I'm dangerous.